Good afternoon. This is our Wednesday, March 13, 2019 meeting of the Lane County Board of Commissioners. It's 1:32 p.m. We had a brief delay because our friends at the Lane Council of Governments, Metro TV, are just finishing up with the Eugene City Council and asked us to start our meeting just a shade later than 1:30. So Commissioner Farr is not here, and Ms. Jones just tried to call him, and he informed her that if he didn't answer, that he wasn't going to be participating in the meeting. Maybe Mr. Mokreisky, you could text her and find out if he's since called in, or
Sure.
yeah, if you wouldn't mind, make sure we get him here if it's at all possible. We have two items on our afternoon agenda today. The first is our item 4A, public hearing in order 19-02-26-05 in the matter of hearing on the record an appeal of a hearings official decision affirming the planning director's decision to approve a replacement dwelling in the exclusive farm use zone E40 on tax lot 1400, assessors map 20-05-13. And with us to introduce this item prior to our public hearing is Rachel Serslev. And Ms. Serslev, who's a planner with Lane County Government, is it time for me to read the procedural rules, or what would you like? How would you like this to go?
Sure, you can start with the rules and then I'll do my report.
Okay, very good. So it first asked me to read the agenda title, which I have done, and secondly, to now explain the purpose and rules of the hearing. The purpose of this hearing is to hear arguments on the record that was before the hearing's official for file number 509 PA 17-05908, a hearing's official approval of a replacement dwelling. This decision is subject to the replacement dwelling criteria at Lane Code 16.2125 and 10. And the procedures for an on-the-record hearing are found at Lane Code 14.08004D7. And this hearing is on the record from the hearing of the hearings official, and the only persons identified in Lane Code 14.0804D7GG will be allowed to participate in the on-the-record hearing, and those who may participate are the director, the applicant, and the applicant's representative, the appellant, and the appellant's representative, and a party of record. And E, argument considered by the board must be confined to the record of the proceedings before the previous approval authority. And F, arguments must be directed toward the approval criteria. Failure to raise an issue to enable a response may preclude appeal to the Land Use Board of Appeals, and only persons who qualify as a party may appeal the board's decision to the Land Use Board of Appeals. Next, we'd like to call for any board members' ex parte contacts, and for any abstentions due to conflict of interest, ex parte contacts, or biases. Do any commissioners wish to make any of those disclosures? And in conjunction with that, Ms. Serslev, I'm sure I remember your name better. I do have my what I call my standard notice in the folder in the file that my lawyer business, which involves legal work outside of Lane County, but one of the lawyers I've worked with is Sean Malone, and my letter explaining that Mr. Malone and I work on cases together but do not discuss his work for other clients, including Landwatch Lane County, that's one of the parties here. So I just wanted to get that disclosure on the record. Are there any other disclosures, ex parte contacts, biases? Seeing none, we'll move on. At this point, we will now hear from staff. After that, we will be opening the hearing, we'll be closing the hearing, and we'll be discussing options for the Board of Commissioners.
Thank you, Chair, and good afternoon, Commissioners. The matter before you today is the on-the-record hearing of an appeal of a hearing's official decision affirming the approval of a replacement dwelling in the exclusive farm use zone. On November 19th, 2018, this appeal was filed and requested that the Board of County Commissioners not hear or conduct a hearing on the appeal and deem the hearing's official decision the final decision of the county. On January 29th, 2019, the board elected to hear the appeal and conducted an on-the-record hearing on February 26, 2019, considering only evidence confined to the record. The February 26th hearing was opened and continued to today for more discussion and deliberations. As detailed in the agenda cover memo, staff recommends that the board move to affirm and adopt the Lane County hearing's official decision amended by the proposed order as the county's final decision. The hearing's official decision was revised by staff to address the correct approval criteria, and revisions involved incorporating the findings, addressing the correct approval criteria. So essentially, staff edited the findings that addressed the incorrect approval criteria in the hearing's official decision, and all other findings and interpretations made by the hearing's officials regarding the appeal issues specifically were not edited, and those would be adopted today as the final county decision. The applicant has indicated that they're in support of this recommendation, but they'll have an opportunity to speak to that themselves today because they're here. And that concludes my summary. I'm available to answer any questions about this.
Okay, do any commissioners have questions of Ms. Serslev before we open the public hearing? Okay, so at this time I'll ask everybody in the room to identify whether they want to speak on this matter, and that'll help me kind of determine how much time to allocate people. Who is here wants to speak on all this? Okay, and what amount of time would you like to request?
No more than 3 minutes.
3 minutes, okay. So, is there anyone else that is going to speak on this? Okay, so come forward at this time. I will. Oh.
I was looking for the sign-up sheet.
Oh, okay, very good. Just come forward, and I will now open the public hearing, and you'll be given a maximum of 5 minutes. So please feel free to give your remarks, and I'll just set my timer here, and you can just give your name and your address and who you're representing, and take up to 5 minutes. Thank you very much.
Thank you. My name's Tom Manfier, and my address is Post Office Box 12257, Eugene 97440. And I'm here on behalf of Mr. and Mrs. Doty, who'd like to replace their home they've lived in for 40 years. It's an unusual request, I'm sure. I support staff's findings that they've prepared for you. We appreciate you taking the time out of your busy schedules to correct an error that made by the hearings official. This is an important function of your role as the final decision makers in the county. I hope you hold on to that role. You've had discussions recently about whether you should keep that or not. We would suggest you do that. This is a great example of why you need to do that. But other than that, staff's done a great job revising the findings, the hearing's official decision, and we support adopting the order as written. Thank you.
Very good, thank you. 1 minute, 2 seconds. I find if I give people more time, they actually use less. Thank you. Thank you so much.
Unless they're commissioners.
Unless they're commissioners, then you got to triple it. Okay, so are there any other people that desire to speak on this matter while the hearing is open? Okay, I see no further request to speak, so at this time we will close the hearing, and we will go on to discussion or action by the Board of Commissioners. And the hearing record is the full, is all the materials in the record, including the public hearing we just had and previous public hearings. So that's our full record. So I'll turn this over to the board. The packet indicates the options that the staff has prepared for us. Does anybody want to be recognized to make questions? While you're thinking about that, I'll ask Ms. Serslev. In the public testimony, Mr. Lanfear said that the purpose of this, one big purpose, would be to correct the error in the hearings official's decision. And what are the errors in the hearing official's decision?
So like Tom said, that this application is for a replacement dwelling in the exclusive farm use zone, and there are two routes that you can take for replacing a dwelling based on what evidence you have that it was legally placed. The main error was that the wrong criteria was applied for the evidence that was supplied by the applicant. So we're pretty much just switching out that criteria, the incorrect criteria that was applied by the hearings official.
Okay, thank you. Are there any other questions concerning this matter, or do any commissioners want to be recognized to either ask questions or make a motion?
I'll make them.
Go ahead.
Okay. I move approval of order 19-02-26-05.
Okay, is there a second? Okay, it's been moved by Commissioner Burney, second by Commissioner Bozovich, to approve order 19-2-26-5. Further discussion on the motion? Okay. All those in favor, please say aye.
Aye.
All those opposed, please say no. And the motion carries 4-0. Commissioner Farr excused. Okay, so let's move on to item 4B. Thank you very much.
Thank you.
Item 4B, while our folks are coming to the table, is the fourth reading and deliberations on ordinance number PA 1366 in the matter of amending the rural comprehensive plan to redesignate land from rural residential to rural commercial, to rezone land from rural residential RR5 to rural commercial RC, and adopting savings and severability clauses, file number 509 PA 17-05144, and the applicant is On the Way Incorporated. This matter is going to be introduced by Amber Bell, interim planning supervisor, and with us also is Ann Davies of the Lane Council of Governments, where she is a principal attorney. First and foremost, Ms. Bell, is Landwatch Lane County involved in this and or not? And is Sean Malone involved in this?
Not to my knowledge.
Okay, thank you. Thanks for letting me know. Are there any other commissioners that have any conflicts of interest or anything like that? Okay. So at this time, I'm going to call on Ms. Bell to introduce this matter. I know this is not a public hearing, but it is a time for board deliberation, set for board deliberations. So go ahead and introduce this matter.
Thank you, Chair. Good afternoon, Commissioners. Again, Amber Bell, Land Management Division, and Ann Davies with LCOG. On January 29th, the board conducted a public hearing on this matter, and at that time closed the public hearing and closed the written record. The item was rolled to February 26th for a third reading, and then from February 26th rolled to today to the fourth reading, and today we're requesting that the board conduct the fourth reading and deliberations on this ordinance. At the January 29th hearing, a number of comments were received in opposition to the request. They cited various concerns that were largely related to the future possible development on the site of either an expanded gas station and convenience store or a future new truck stop. The Planning Commission has recommended approval of this ordinance, and their approval of this application, or recommendation for approval of this application, was informed by the fact that these concerns raised by public comment largely relate to the future development proposal, and not to the plan amendment and zone change criteria for the application. The board on January 29th voted in opposition to a motion to approve findings as presented by staff, and at that time expressed interest in staff exploring potential bases for denial. Staff have researched potential reasons for denial extensively. We've looked back through all applicable criteria and the policies, and there does not appear to be an obvious policy or criterion that the application does not comply with. And for this reason, staff will be recommending approval of the ordinance today. There are some general policies and criteria that the board could take into consideration in your deliberations today, and Ann will be walking through each of those considerations here in a moment. Of course, the board may deliberate on the matter and reach a conclusion that is different than staff's analysis, and if so directed, staff will revise the findings and return for a subsequent reading to incorporate the board's deliberations. Before I turn it over to Ann, and she provides the remainder of the staff report, I'd like to turn it over to County Counsel, who will provide some information about the quasi-judicial deliberation and decision-making process, and also some of the parameters for reversal or remand by the Land Use Board of Appeals should this ordinance ultimately be appealed to LUBA.
Thanks. For the record, Andy Clark, the County Counsel. Our office has been requested to provide a training on legislative versus quasi-judicial decision-making. It's in the works, but as a preliminary matter, it comes up here, and so I'll talk a little bit about that. This, for reasons I won't go into, is a quasi-judicial, or calls for a quasi-judicial decision rather than legislative. And because it does, it implicates certain procedural protections, both for affected property owners and also for the applicant. Property owners, for example, in a neighborhood will get notice of potential development so they can appear and give testimony. The applicant as well has certain protections which include having a decision based on the standards that are relevant to the development application on file. And because of that, it also triggers, well, I should say, the statute and rules that talk about those protections are relevant to the land use decision-making anyway, require that as I said, the decision to be based on the standards that are in the books now and be based on evidence that's in the record. The rule also requires that findings be made as part of the decision-making which relates the evidence and the standards together, whether it's a lack of evidence or the existence of evidence that sustains a standard. And that's what we were talking about a little bit the last time we had any substantive discussion about this, the 29th, I think it was, whether or not those standards had been met, whether there was evidence to sustain them or not. And that's why staff is recommending approval in this. It's their opinion that the standards have been met. If the decision is made and there aren't suitable findings that adequately connect the law and the facts of this case together, LUBA will look at that and remand it back for lack of findings. There are instances where LUBA will sort of forgive the lack of findings if counsel at argument or in briefs can point to evidence in the record that sustains a certain standard or not. But our job at this stage is to make sure we've got adequate findings making that connection and not leave it for the appellate body to do for reasons of efficiency. So that's where we are now. And in the short of it is, if the board wants to approve this application, we need findings that make that connection between standards and the facts that substantiate that finding. Or if the board wants to deny it, again, we'll need findings that show what standards have not been met by a lack of evidence or conflicting evidence, for example. And so with that, I'll let, if there are questions, I'm happy to field those. Otherwise, I'll let staff talk about the specifics of the standards here.
And are there standards that are applicable in this case where you think, at least thus far, the evidence in the record, and now with our deliberation today, no additional facts in the record that apply in this case? Like that they've met, that the applicants met them?
Yeah, I haven't made that determination, for example, but that's in the planning commission's finding and recommendation, and as well as staff's, yes.
Okay.
So this is Ann Davies with LCOG. I just want to be clear, my role here is a contract that LCOG has with the county to provide staff services. I'm an attorney, but I'm not acting as an attorney. So I'm just kind of like a secondary staff person who's helping, doing some background work. So just kind of the perfect segue from what Mr. Clark just mentioned about what staff's recommendation is. I mean, the Planning Commission and staff have recommended approval based on their review of the evidence and the approval criteria that they believe apply to a plan amendment zone change application, which is what is before you. I think a lot of what happened in this case stemmed from the applicant's desire to let the county know what their plans were for the property. So in the application, there was quite a bit of information addressing a possible proposed development, which was the expansion of the existing gas station and potential truck stop. So with that information, the opponents in particular went forward addressing those concerns of conflicts with that particular potential development. The Planning Commission, during their deliberations, seemed to be going down the road of being very concerned about those conflicts, potential conflicts with the proposed development. And it was really only when staff explained, this is the plan amendment zone change process. There's another process to deal with that proposed development that will require what we call a type 2 process. And that type 2 process is something, we mention that because that means that the opponents will get notice of that future process and will be able to appear and voice their concerns about the impacts that development will have to their property. So I just wanted to make all that clear of the history of how the Planning Commission came to it and the staff's recommendation prior and in this meeting. That said, we understand that the board at the last meeting had voted 3-2 to deny the application. What we did in our staff report was outline the potential approval criteria that the board would probably want to focus on if it really decided to deny the application. So there may be other approval criteria out there that we didn't identify in the supplemental staff report, but what I'm going to do is just go through those approval criteria that we identified that we think are at least the closest to providing some avenue for potential denial. The staff report highlights all of those, but I'm just going to go through them again and try to explain them. And forgive me if what I want to do is I want to provide information for those newer commissioners who haven't spent 20 years in land use planning in Oregon. And so if I'm too high level or too low level, just let me know. I'm trying to cover everybody who's in the room here. The first policy that we look at is in the Rural Comprehensive Plan, Goal 2, Policy 8. And the reason we're looking at that is there's a criterion in the code that says when you're doing a plan amendment, you need to show consistency with policies of the comp plan. So what we do is we go through the comp plan and we pull out all the policies that we think might apply. And so I think this was a policy that the applicant actually pulled out in their application and said, here's a relevant policy, this is why we comply with it. And so staff looked at it. Sometimes the staff pulls out their own policies that they think apply even though the applicant hasn't done so. So Goal 2, Policy 8, in reviewing all of the comprehensive plan policies was a provision that staff thought maybe the board would want to rely on. And it says, existing industrial and commercial uses shall be designated on the plan diagram. Uses so identified shall be zoned to allow for continued operation and routine expansion commensurate with their character, provided significant conflicts with other land uses existing and planned do not result. So that criterion was originally identified, I believe, by the applicant because it specifically calls out the ability to expand existing uses and says that that's what we should be doing. If there are existing industrial and commercial uses, and this is in an exception area where it would be appropriate to do so, then we can look at expanding those uses. You could look at it another way and say that that expansion maybe provides significant conflict with existing uses, which are the residential uses that are nearby. Those were the residents that you heard from at the hearing who think that this potential use would conflict with their living in that area. The staff report also mentioned that this is kind of a generic policy. Most of them are. But you would definitely need to articulate clearly the rationale and the evidence that's in the record that would allow you to use that approval criterion to deny the application. So then we move to another policy, Rural Comprehensive Plan Policy Goal 5, Policy 12. And Goal 5 is the statewide planning goal that deals with natural resources and the ability to protect natural resources from conflicting uses. And the policy reads, if uses are identified, which were not previously identified in the plan, which would conflict with the Goal 5 resource, an evaluation of the economic, social, environmental, and energy consequences shall be used to determine the level of protection necessary for the resource. Procedure outlined in the Oregon Administrative Rule will be followed. So this is basically just a restatement of kind of the Goal 5 EC, it's the ESEE analysis, which looks at the different conflicts and what the potentials are for conflicting uses with natural resources. It was identified that there's a possible wetland, big game, and groundwater were all issues that came up in the testimony from the neighbors. And the findings by staff were that none of those actually rose to the level of a real conflicting use that would preclude the proposal of just the plan amendment zone change. We called it out because we thought if the board wanted to look closely at that, they may be able to come up with some different findings based on the evidence, although, again, staff hasn't been able to identify those. Rural Comprehensive Plan Goal 12 deals with transportation. There were definitely some transportation issues raised by the neighbors regarding additional trucks accessing the property off of Highway 58 and Wheeler Road. When you're dealing with a plan amendment zone change with regard to transportation, the transportation planning rule, which is the administrative rule that the state has adopted to implement statewide planning goal 12, comes into play. And the first step of that is to determine whether there's a significant effect of a transportation facility. And the record, as it stands now, includes testimony from an ODOT traffic engineer that says there will not be a significant effect. And there's no expert or other evidence to the contrary. There's testimony from neighbors who are concerned about that safety, but in staff's opinion anyway, that expert evidence that's in the record, it would be really hard for you to say that there's evidence from the neighbors that are not expert evidence that would outweigh that expert testimony from the ODOT engineer. So those are the approval criteria that we pulled out that could apply to the plan amendment phase. There are also lane code provisions that deal with the zone change that we pulled out. And those are lane code 16.004 subsection 4 that says prior to zoning or rezoning of land under this chapter, which will result in the potential for additional parcelization, subdivision, or water demands, or intensification of uses beyond normal single-family residential equivalent water usage, all requirements to affirmatively demonstrate adequacy of long-term water supply must be met as described in lane code. And then it cites to the provisions in the code that deal with water adequacy. So this is a provision that staff has concluded is satisfied, potentially could provide the board some ammunition, although the property and the surrounding properties in this area are not designated water quantity limited areas. So that fact takes us kind of out of the the area that we were talking about yesterday. There was a case that you heard yesterday where the facts were a little bit different, and you imposed a requirement for a well test prior to subdivision approval. And the findings in that case were based on the fact that the area was water quantity limited. And this area is a little bit different. So that's one that we pulled out. And then Lane Code 16252 subsection 2 has some really broad language that pulls out the approval criteria for zone changes about that you have to show that it achieves the general purpose of Lane Code Chapter 16, and then you go to the purpose section of Lane Code 16, which are pretty general. Be consistent with the specific purposes of the proposed zone, and the code 16.291 includes purposes of the rural commercial zone, and not contrary to the public interest. So those are the approval criteria that we pulled out as possible avenues for the board to direct staff to adopt findings for denial. If you do choose to go down that route, staff would hope that you can articulate really clearly what your thought process is and where relevant evidence in the record that would support findings so that we can rely on that in drafting the findings. And then I think, Amber, did you have something else you wanted to add or not?
Just to reiterate that because many of the concerns relate more to the future potential development proposal, and we anticipate that that would require more than likely a type 2 planning director process, there is a use in the rural commercial zone for service stations and auto repair garages, and there's also a use listed for uses in development similar to uses in development allowed by Lane Code 16291. Those are conditional uses. There's criteria that apply to those uses. If the applicant made application for the gas station expansion or truck stop under those uses, they would need to meet all of the approval criteria, and approval is not guaranteed. So they would need to make application. A public notice is sent out for a type 2 planning director application, and the application would need to demonstrate compliance with each criterion, some of which include some compatibility related concerns. And then the public, then adjacent neighbors who receive notice, interested parties could participate, provide public comments. They would have the opportunity to appeal the type 2 decision, and then if appealed, that would go to a public hearing before the hearing's official. So I just wanted to reiterate that, and again, because staff has not identified any clear basis for denial at this point, we are recommending approval.
Are you done with your presentation?
That concludes staff's presentation.
Thank you. I was going to ask you if in the Planning Commission recommendation, they made recommendations for conditions that are attached to their recommendation. In other words, to make sure that the public process is protected for the neighbors that want to give their views. And for example, what you were just addressing, namely uses that are in the code for lands if this is in fact redesignated.
They did not include any conditions of approval in their recommendation.
Is that something we could do if we wanted to approve the change in the land use, but put conditions on, as we did in the other case with the aquifer testing?
It's something we've discussed with the Planning Commission on different plan amendments, and I think including this plan amendment application where there were concerns related to compatibility. But any conditions would need to relate to specific approval criteria.
Well, that's what I mean. Is it necessary, or is it to be clear that we're not just approving a truck stop, but we're complying with the land use law that you identified, that the approval criteria seems to have been met, but it doesn't necessarily mean that any given design or any given application is going to get approved? Is there any way of putting some sidebars on this?
To the extent that they're related to approval criteria, yes, there is some options. It is a little difficult from an implementation standpoint, because if an application comes in the planner on duty would need to be aware that there's conditions that are tied with the plan amendment and zone change. Sometimes that's done through like a site review suffix so that it's immediately clear on the zoning map that there are conditions unique to that site that apply. But if conditions are just related to the scope and nature of a future development proposal, then that would generally not be something that we could condition at this time. It would need to be related to the considerations of the plan amendment and zone change.
Yeah, and just to throw in my 2 cents, the condition would need to relate to the standards applicable to this application. If what you're talking about is what sort of development could occur on the property, that's kind of covered by the land use code that describes, what uses are allowed on the zone property. If you want to impose conditions relating to certain standards here, there's got to be a connection between meeting that standard and the condition imposed.
Well, what about the one that it relates to transportation? They were, you said the facts in the record are that the ODOT has something in the record that sustains the view that the transportation goal has been met. Well, a truck stop is a transportation facility. It certainly is related to one of the approval criteria for this decision. So couldn't that be part of the, if the board was going to reverse its, previous vote?
Right. As far as transportation goes, generally the board or the decision maker evaluates the nature of the evidence received. And if you've got someone testifying A and another testifying B, you can consider a whole bunch of stuff surrounding which testimony you want to believe if they conflict. However, in the cases where you've got a matter of expertise, in this case, traffic engineering is the expertise, and you've got engineers giving you testimony and sort of seat of the pants kind of senses of people's fears about what may happen, with future development, unspecified. You've got sort of different levels of evidence you're trying to compare, and I can't remember the cases exactly, but I know that I have read a number of cases where LUBA has remanded those things back, saying unless you've got evidence of the nature of expertise, it's pretty hard to sustain.
I got that, but what I'm talking about is not approving the proposal, but rather, not denying the proposal, but rather approving the proposal. And as I understand, Ms. Bell, that we can put conditions that are related to approval criteria, and one of those approval criteria is transportation. Can we put that?
You can. In my estimation, that would be challengeable on appeal because it's not necessary to sustain
This decision. It's not necessary to sustain this decision.
Right.
If I may, typically when conditions have been imposed in plan amendment zone change applications, it's to address a deficiency in the application. So in this instance, ODOT has provided testimony saying that essentially the goal 12 has been met.
Now, I'm just going to blurt this out. This is the former country lawyer version of this, but I'm not hearing that in approving this, that the Board of Commissioners' decision would be upheld at the Land Use Board of Appeals. It looks to me like just the opposite would take place, and I'm wondering if you can help me, if that's the case, is there anything we can do to respond to the fears of the neighbors? Is there anything we can do to respond to the legitimate concerns of the neighbors that they're not going to, is there anything within our purview that we could do?
Chair Sorensen, if I may, this is Peter Miller, Interim Planning Director. One option that may be available to the neighbors is that if the board were to choose to approve this zone change and plan amendment and then come in subsequently with an application for the expansion of the commercial use, there is an option to elevate that planning director review to a higher level and have a hearing on it. So we could, with the level of interest in the community, that's something we could entertain doing. And that's a process that we could go through, and they would have an opportunity to not just provide comments into the record, but to actually come in and speak to the matters again, to the specifics of the impacts on the community.
Okay. Any other commissioners want to ask questions or otherwise be recognized? Go ahead.
I guess I just, it's back to, where we were before somewhat. A couple of board meetings ago, there really isn't, a clear way of making findings of fact that are not going to be appealed and probably overturned or remanded to recommend a denial on the zone change. And that's one of the reasons why I made the motion to approve the zone change. And I would hope that maybe with a little bit of time and thought and a little further explanation from staff, folks understand all we're doing is doing the zone change based on the criteria for amending the comprehensive plan and that zone change. We're not giving approval, site plan approval this time. That's a different process that has an appeal, out, and can go through the whole, all the way up the appeal ladder, when they get to that process. With that all in mind, that it's difficult for us to attach conditions because we have to have findings that say that condition is related to zone change, not the future development, or else that won't stand up in LUBA. It'll get remanded. So with all that in mind, I am going to move approval of ordinance 1366.
Okay, it's been moved to approve ordinance 1366. Is there a second?
I'll second for purposes of discussion.
Okay, it's been moved by Commissioner Bozovich, seconded by Commissioner Buck to approve ordinance 1366. And for discussion, Commissioner Bozovich and then Commissioner Buck.
I kind of gave my discussion up front, so
Okay.
I'll pass.
All right, Commissioner Buck and then Commissioner Burney.
And this is challenging for me because of all the testimony that occurred before. And I hear what staff is saying about the potential issues for possible remand. Again, everything's always appealed, generally, either side, in many cases. So, I see the three potentials that we could be doing here. The issue is we haven't even had our work session on quasi-judicial process. So I don't feel comfortable making really any decision until I'm better informed on these. And so I'm gonna leave it at that, and we can all have more discussion.
Okay, Commissioner Burney?
I found it interesting that all of this is prefaced as not remediation per se, but some orientation for new commissioners, and new commissioners were not the ones that have weighed in all that much thus far. I feel the same conflict. I felt, and I'm learning the job, I felt that the neighbor's testimony was compelling. I even made a statement, and I recollect this very well, that I said that I said I could sense the angst, and if I recall correctly, Commissioner Bozovich let me know that angst was not a criteria upon which we make these decisions. We have not yet had any kind. I have requested from AOC to county staff that we have a work session on the quasi-judicial role of commissioners in land use decisions, because as I'm hearing evidence and guidance, it feels like you all are going, you guys, don't you realize you don't have any option? Could you just get on with this? That's what it feels like. It feels like we're confined and constrained and not allowed to have the discretion of being a legislative or policy body in this role. So I'm caught betwixt and between also. If, in fact, we approve this zoning change, somewhere in the appeal process, will folks come to us again? Will this body again be involved in the hearing of what some future development might be if, in fact, there's that same consternation?
Well, potentially. Yeah, as Mr. Miller was stating, this is, well, back up, I guess. As we've already said, most of the neighbors who expressed concerns about the proposed comp plan amendment rezone have expressed issues that are really relevant to the
To
development.
the potential development
Yeah.
in the future,
The
right?
potential applications, and it's really difficult, and I understand I know why you're struggling, it's very difficult to relate those things to this application, and for us to interpret that, because they're not meaningful critique of the
Understood.
standards
Right.
that are relevant to this part of the decision-making. Step two, the development decision, as Mr. Miller was stating, typically it would be a type 2 decision, which means the planning director would take in the application and evidence supporting the application for development and make a decision. And if that decision was to affirm the application, then opponents have an opportunity to appeal it, and that's where it goes to the hearings official. And if that decision is appealed, then up to the board.
Okay.
What Mr. Miller's describing is sort of skipping that first step of the planning director decision and taking it straight to the hearings official, right? And the hearings official would conduct a full hearing with hearing from everybody who wanted to speak and all the relevant issues. Whether this board would get another shot at that one depends on whether that decision is appealed. We can't say for sure, have no control over that, but that would be the board's.
No, thank you. That answers.
I want to throw out an idea that I'd like to hear your staff's reaction to, and that would be that within the next month, we expect to have this briefing on the topic of quasi-judicial work of the Board of Commissioners, not only within land use, but in other areas as well. And so rather than come to a decision today on our deliberations and conclude and make a decision one way or the other, we could hold this over for, let's say, a 2-month period, and then we would have the deliberations on this matter in 2 months, with the idea that our other kind of briefing that Commissioner Buck mentioned, that we were going to get an update and briefing on the board's quasi-judicial kind of judge role as opposed to lawmaking role.
A training, right? Not a briefing, but a training.
A training, briefing,
I'm sorry. Okay.
all of the above. I mean, staff, including Mr. Mokahiski, because that does involve the board's schedule. But I just want to get that idea out there so that we, because I heard Commissioner Buck say that all things being equal, I don't think he wanted to make a decision today, so.
I've got two reactions to that. One is, yeah, you can set this over for another reading, provided that that is okay with the applicant, frankly. And that's one of the protections built into the quasi-judicial decision-making process, is that applicants are due a decision, unlike a legislative matter where the board can decide and do nothing. But in this case, you can't. You have to make a decision, yes or no. And in addition, the rule or the statute requires the decision to be made in a certain length of time. And if you go beyond that time, the applicant can file a mandamus action, which drags us all over to circuit court. And the circuit court says, county, tell us why, you can't say yes or haven't said yes to this application. And so that's the first point. You can't continue.
Yes or no, I guess. Yes or no.
Although I think things differ in this context a little bit because it's a comp plan change. But that being said, you can't continually roll over and delay quasi-judicial decisions. Permit decisions have a specific day requirement. This is not a permit yet. The next step would be. The next thing I was going to mention is training is all well and good. Nothing about that training, frankly, is going to be revolutionary in the sense that you'll gain enlightenment as to how to deal with this matter, because frankly, this matter is pretty simple, in that the only thing you need to understand about the quasi-judicial decision-making role you have here is that you have to base the decision on the standards that are relevant, and you have to identify the facts or the lack of facts that sustain or don't sustain one of those standards. And that's really all we will tell you in the training about the role here. And so that's not going to change. But
Did the applicant agree to this delay that we had?
I don't recall what we've got. I guess,
We don't have anything specific.
yeah, there's no specific waiver. Oftentimes we'll have a timeline waiver from applicants. If it's what's called a permit application where you've got specific 150 days, we need to make a decision. This is a comp plan change, so there isn't a specific.
What I'm saying is if the applicant didn't concede to a fourth reading and deliberations on this, then maybe the board doesn't have authority to discuss it because the board
No,
didn't meet its statutory duty to decide things within a reasonable time.
I think, to be clear, to clarify what I said, I think the board has the latitude to delay this if you want. I guess my point was, at some point, the board needs to take an action, and if it gets moved on too long, then the applicant may have rights if they choose to exercise them.
Okay, very good. Okay, any other ideas? Yes.
So-
Sure.
There, like Andy said, I don't think there'll be anything truly enlightening in the training beyond what he said, but also, there's a responsibility to the applicant that we make a reasonably timed decision. And we've already delayed it once because we couldn't come to a conclusion in the meeting where I originally made the motion to approve. And at that time, our chair, who has been involved in land use applications for years, couldn't describe to staff what findings to make for a denial when he was supporting the denial. So that's over 20 years of experience. So so at this point, I'm kind of wondering, I know you two don't have 20 years of experience, but, we're looking at, what it basically comes down to is we have a set of criteria that the applicant has to meet based on evidence placed in the record. And there either has to be evidence placed in the record, because we can only make decisions based on the record, that show that either the applicant's evidence is incorrect or inaccurate, or some kind of conflict to it, or not. If the evidence that's being placed into the record by opponents doesn't address the criteria, like it's addressing the future development, it's not evidence we can use to make findings. So that's what the real issue is here, is all this angst about the future development is about future criteria that will be applied at the site development time. What we have is what applies to the zone change. So what do we have in the record that supports the zone change? Planning Commission staff have both said everything's been met. And I've walked down it and I can see that criteria has been met. So it's kind of, what more training is going to change those facts? Because, part of a quasi-judicial is you got to stay with the record and you got to stay with the criteria. So the criteria aren't going to change. The evidence in the record's not going to change. So whether we have training in a month or not, none of that's going to change. So if you're not comfortable with the fact that your decision today really is, does the evidence support the findings for approval based on the criteria? And I look at it and I say, yes, it does. The Planning Commission did, staff has. So that's why I made the motion to approve last time. That's why I'm making the motion to approve today. And I think it's fair to the applicant to move this on. All the neighbors have the opportunity to appeal this. And I'm certain they probably will. And they'll test that. They can appeal this, and they probably will. That's just the nature of land use I've seen over time. And that's, But I think we've got a well, recommended decision, well-balanced decision that has evidence for each of the findings, and I think we can move on.
Commissioner Bernie?
Two things, and these are going to sound conflicting. One, I'm trying to find every which way I can to deny this, and I can't, based upon what I'm learning. And two, I want to remind everyone that when it was a very awkward moment when we made this decision, and for the first time in my life, I heard, what are the findings that support the decision? New process, and there was silence. Okay, I understand that. But I also want to remind everyone that the solution to that, I didn't come up with training. The solution to that, I was told, was that we needed training on the quasi-judicial role of the Board of Commissioners when it came to land use. So I just wanted to point that out, and I also, at this point, can find no way to avoid reluctantly approving the zoning application.
Okay, any further comments on the motion before the board? Okay, we'll go to a vote. This being a ordinance, we'll ask Mr. Mokohiski to poll the board.
Commissioner Bozevich,
Aye.
Commissioner Bernie,
Reluctant, aye.
Commissioner Buck,
Nay.
Commissioner Sorensen.
Aye.
Passes 3-1.
Okay, the ordinance is adopted on a 3-1 vote. Commissioner Buck voting no, Commissioner Farr excused, and that concludes this matter. Maybe as a follow-up, we can find out when, if we know, the quasi-judicial briefing that we're going to be having.
Coming soon.
April 2nd.
April 2nd, okay, thank you.
Just
And,
2 weeks.
yeah, and then,
Thank you.
and then, let's see, we are now down on our agenda. The audience is, you can say if you like, we're having more public meeting, but your item has been concluded. Thank you for coming. So, let's see, we are now at, we're now at item 5, the review of assignments. And did we do this yesterday too, Mr. Mo?
Yeah, it's just, this is for if there were any assignments that came out of today, but I don't
think there
have
were.
any.
Okay, no assignments yesterday, other than maybe a reminder that April 2 is our date for the, okay. We do not have any further executive session, and I know that we've had this catch-all other business, and because we want to make it possible for people to raise issues that haven't been otherwise raised in all the other processes we have to raise things, but I will ask if there's any other business.
Just a quick note, the board received an email from Councilor Green in Florence about the urban renewal area there. I had conversations with the mayor and checked in with our economic development staff. Basically, they're codifying what's in the bylaws now, that the mayor has always made those appointments. Generally, they come from the agencies that Mr. Green was concerned about, including myself as a member on the Urban Renewal Agency. And I don't have concerns. I don't believe there's really a change in the process happening. I think it's just the fact that they're reflecting what the bylaws of the agency say in city code.
Okay, anything else?
I had a letter from the Parks Advisory Committee regarding forming a task force. And they wanted to recommend the board authorize county administrator to request a formation of a task force to dedicate funding options to ensure long-term financial stability of the Lane County parks. And So I didn't know if that specifically meant that the Board of Commissioners needed to be able to authorize you to do that, or if that's something that you could do in the course of your work with parks. Just wanted to bring that up.
I think it's a good thing to bring up. Thank you for doing that. And I'm wondering what, Mr. Mulkreisky, your initial reaction was to that, or where you think it should go, you know, oh, okay.
First, I didn't see, I didn't
It came
see it, so
in,
I'm not sure if
I think it came in while you and I were out of town.
Okay.
And I remember it coming in as a written document like that. I mean, it wasn't an
Right, it did come
email.
through email, okay.
So it
Forget
was,
that this form of communication is.
the snail mail does
Yeah.
exist. And
Probably didn't exist when you were younger.
yeah, yeah. But anyway, maybe the way to deal with this is to give you a chance to read that, and then maybe next week during your your administrator announcements, maybe get Parks to give you a little feedback on that. Because I do think that when we spent, and this is for the benefit of our viewing audience as well as all commissioners, but we did have an extensive parks planning process that we paid good hard money, as my grandfather would say, to consultants, and we had extensive.
That's when money was hard.
Is right, and it was, big coins. And so we paid for that. We got a great public response, lots of meetings and lots of input. And so now I think, and that was approved by the board in December. So I think what they're trying to follow up on is, okay, now, I believe it's the line from the movie, show me the money, because it's going to require money to implement that. And we're now on to the next phase. So I really think it is something that we should get the feedback of Parks on, and then maybe set up for a board session on it, because it is something that they want to work on, and I think we should follow up.
So I did have an opportunity to meet with Kevin Shanley, who's on the Park Advisory Committee, several weeks ago, and he brought this up. I think it's a great idea to do. One of the things that we've been, and as we're now, I'm now heading in over the course of the next couple of weeks into department meetings on budget, to hear from departments on their requested budgets, and then formulate the proposed budget that the Board of Commissioners and the Budget Committee will receive in the end of April. So one thing that I've contemplated is, will there be some resources to put towards parks? Maybe it's one-time resources for some deferred maintenance or capital improvement that could generate additional revenue, and the potential of proposing a task force. So I think that my comfort level would be, we can work with Parks Division, with the existing Park Advisory Committee, and try to formulate a recommendation for the board, but I still would want the board, I think you need to know what this group is, who's gonna be on this group, what's the charge of the group, because ultimately their recommendations are gonna come back to you. But a couple examples, we did the large events task force that the board authorized, but I think it ultimately was sort of under the direction of the administrator, and the recommendations came back to the board. And then the other was with the master plan, and the two new commissioners, this was at the end of 2018, so you didn't get to see.
December of 18.
December of 18. But that task force that we used to really gain public input from geographic diversity of the county was a county administrator form thing. So I think, again, we can have a balance where we can sort of structure who, what, where, but have the board approve that and make any suggested changes. So that's my thought process at this point, is to make a recommendation in the budget, in the proposed budget, and then the board can make adjustments there if desired.
Okay,
It's a good idea.
yeah, okay, good. Anything further? Okay. All right, so seeing no further business of the Board of Commissioners this week, and we do have a meeting, we have a set of meetings next week, March 19 and March 20. I know the Legislative Committee is meeting on tomorrow, so Commissioner Farr and I as well as department directors will be in on that. And as far as I can see, we're done. Anything further? Okay, then we are adjourned. Thank you so much.